topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. Hey, listen, I don't need a watch. I don't need a calendar. I always know my phone starts buzzing at 5 o'clock on Thursdays, the first Thursday of the month, which means the K. Bender Rimbaum Hour. They have been with us for about 13 years. It is our number one show of 35 shows that we do. It's our number one show based on the amount of your emails and your texts that you sent in, even up to 2 and 3 weeks after the show. We're so lucky to have senior partner K. Bender Rimbaum, Robert K. Good afternoon, Robert.
Hey, Steve. Hello, everybody.
We're
Happy
doing
Thursday.
good. Yeah. Hey, listen, you are so at the top of our list. All right. This has got people love your show. We get emails just saying the board listens to your show every month. And I know you appreciate it because your firm is so involved in educating people. There's so many things that you do, and I was just looking at your schedule for the month of April. Oh my God, Robert, I can't believe all the things that you're doing the month of April.
We've got some live things, some Zoom things, interesting topics.
Great topics. So, we're always finding new people are finding the show. Tell people about K. Bender Rimbaum, the community association law firm.
Well, as you say, K. Bender Rimbaum focuses our practice on representing community associations, condominiums, homeowners, cooperatives. We do so out of our 4 offices, in Pompano Beach is the main office, Palm Beach Gardens, Tampa, and Winter Springs in the Orlando area. We provide basically full legal services to associations, be it a review and analysis of their covenants, legal opinions as to the rights and responsibilities of the association, the individual owners, collection of unpaid assessments, contract negotiation, construction defect issues, zoning issues, dealing with code enforcement issues. Anything that an association is going to face on a day-to-day basis on legal issues, we will address in a timely, efficient, and cost-effective manner at K. Bender Rimbaum.
I got to tell you, Robert, you've developed over the years, have developed such an incredible law firm. And I got to tell you, it's not just what you talk about, but people love the way you explain each thing. And I think just so people really appreciate you taking this hour once a month, and you also do it in your Tampa office, in your Orlando office. I got to tell you, people so appreciate your firm.
Well, I'm happy to be here.
So the way this works is what we do is we go about 4 weeks from each show, and we take your text questions. We always get at least 25 to 30 questions, and sometimes we can't answer them all. And we also allow you to write us questions on the chat line if you're watching on YouTube. So that's how we start. And let's get started with Rocky in Pompano. How far in advance do condo election notices need to go out, and what information needs to be in there?
Well, we are in election season, so that's a good timely topic. For condominiums, the requirement since 1992 is that there be first a 60-day, what's called first notice of election. That's to a minimum of 60 days before the election date. The notice will be sent to all unit owners, and it informs them that any individual owner that wishes to place him or herself into nomination to run for the board may do so, and has to submit their form of their notice of intent to run by 40 days before the annual election. And that date is set forth in the notice. And that notice should include a form, typically does, for the owners to fill out and return. And there's usually not much else in it but that. After the 40th day, when the time frame is set for the candidates to run for the board, each are afforded another 5 days to submit written bio information that they want to include with the second notice, which is optional. They don't have to, and often don't, but they do have the right to submit that. Then after the 35th day, no more than 34 days, but no less than 14 days before the election date, the board sends a second notice. And with the second notice will be a ballot that contains the names of the candidates running for the board in alphabetical order, no indication of who's an incumbent, who is not. It will also contain 2 envelopes, an inner envelope for the ballot to be contained in that doesn't have anything written on the outside other than maybe the word ballot, and then an outer envelope that the inner envelope and ballot go into, which contain the return address of the name and of the voting unit owner and their signature. And that is sent into the association or hand delivered to where the association is collecting the ballots. And they can generally do that up to the date of the election. And once the meeting begins, no more ballots can be accepted. So that's the basic process prior to the election.
Robert, we get a lot of people about asking questions about annual meetings. Jack in Deerfield says documents for annual meetings for our condo says 60-day notice. Does it have to be 60 days?
Well, it has to be at least 60 days. It can be more than 60 days, and that's just the first notice. We talked about that with the prior caller. So yes, it has to be at least 60 days.
Okay. Shelley in Boca Raton, our board watches all of your shows. We can't thank you enough for educating us. I don't have a question. I just wanted to let you know there's a lot of us watching your show.
Well, hello to you all.
Yeah,
thank you for watching.
Definitely know that.
Listening.
Chris and Davey, another one. I love your show. I never miss one. Many of our board members also listen. Is the corporate transparency document done?
You're referring to the Corporate Transparency Act. The federal government had enacted requiring many corporations throughout the country to submit documentation. As of the current time, it is done. It is not a requirement. I understand there is some talk of a repeal of it, but the agencies in the federal government that were collecting it are no longer collecting it. The current administration is not in favor of it, so I don't anticipate that's going to be an issue again.
Mary in Boynton Beach, HOA, and again, thank you for. We really need to know if you're an HOA or a condo. So
oh yes.
we appreciate it. She wants to know, how do we go about a recall on our board president?
Recall of board members are done either at a meeting or through a written agreement. And that's a form document that the Division of Condominiums within the Department of Business and Professional Regulation in the state of Florida up in Tallahassee, on their website, they provide forms for both HOAs and condominiums. The division does have jurisdiction over recalls in HOAs, so it's limited. They don't have a whole lot of jurisdiction for HOAs, but they do for recalls. So there's a form that you can download from the division website. It spells out in fairly straightforward ways the procedures required. You have to list each board member's name that you're seeking to recall, with an opportunity for the owner to check a box that either is for or against the recall. If you're attempting to recall more than a majority or more of the board, then you should have replacement candidates' names in there as well. There needs to be a unit owner representative, the name and contact information included with the form, and then you collect the appropriate signatures from the voting representative for each of the properties. And once you have a majority of those or more, and it's always better to have more in case there's a problem with any that you collect, those have to be delivered to the association either by certified mail or by a process server in order to be completely and properly presented. And then the board has to evaluate whether or not it's a valid recall.
We're going to go one more question before we get to your April schedule. Jerry in Boca Raton, our term limits are in May. I'm a condo board member. It is very hard to get people to run for the board. How long can a person sit on the board?
Well, in 2018, the Condominium Act was changed to provide for a term limit of 8 years starting July 1, 2018, for consecutive service on the board, with the exception that you could serve longer if there is no other candidates willing to serve, or a supermajority of the owners vote in favor of you continuing. So those two things could happen. 8 years from July 1, 2020 or 2018 would be June 30, 2026. So whenever you began after 2018, you have 8 years before the term limit on the statute kicks in.
Robert, what do you advise condo associations or even HOAs who have a hard time getting people to run for the board?
That's a difficult question because it's generally not a legal issue. It's more a political one.
Yes, that's true.
We see in many communities when everything's being handled well, the assessments on a regular basis are manageable and the community is well maintained. It's not unusual for owners to leave things go as they are and leave it in the good hands of those who are already serving. But, you know, they're volunteers, they're not employees, and they have lives too. And it's a good way to live within communities, providing some volunteer of your time and services to your association to protect the investment you have in your home or your condominium unit, because how the community is maintained and kept up will have a direct correlation to the value of your home. And paying attention and being involved is important, and every owner should be participating as much as their schedule allows them to do. How you can get people to do it is never an easy answer because it's going to be different for each community. Board members should be in touch with everybody in person as much as possible, and to maintain the interest and try and keep them engaged.
We also get a lot of emails, people asking, do you think if board members were paid, it would be easier to get board members? Actually,
Well, that's
be easier or better?
Slippery slope as well. Certainly, people might be more inclined to participate if they're getting paid for it than if they're not. But in order to pay board members, there are legal hurdles to clear to do so. A lot of communities have toyed with the ideas of having outside board members, people who don't live there, and they, of course, would want to be paid for their services. But the level of interest may be different. So it's really a hit or miss kind of a situation.
Okay, let's go to your April schedule, and you.
Okay, we are very busy.
Yes.
Starting on April 8th on a Zoom, 11 a.m. to 3 p.m. We have a condo board certification webinar. Kirsten Hentz from Tampa and Danielle Brennan from Palm Beach Gardens will be presenting, and it's co-hosted by GRS Management. On April 10th, from noon to 3 p.m., we have an HOA board member certification webinar. Emily Gannon from our Pompano Beach office will be presenting, and it's co-hosted by Affinity Management Services. On April the 16th, we have a live event in Tampa, the Tampa Expo at the Tampa Convention Center. We'll have a booth at the convention, and Kirsten Hentz will be teaching at 9:30 covenant enforcement for condos and HOAs, and at 2:30 2025 legal update, which are the laws that were adopted in 2024. On April 17th, there's an ACE Boca breakfast at the Farmers Table in Boca Raton at 7:30 a.m. Covenant enforcement for condos and HOAs will be the topic, and Emily Gannon will be in person and be presenting. 7:30 a.m. Farmers Table in Boca. On April 22nd, we have the Palm Beach Expo. And by the way, the Boaard Expo is today, so there's not much to talk about it now. Palm Beach Expo at the Palm Beach Convention Center. At 9:30, we'll be teaching covenant enforcement for condos and HOAs. Danielle Brennan will be teaching that. And 2:30, 2025 legal update presented by Jeff Rembam. On April 22nd, also at noon to 1 p.m., we have a webinar, The Importance of Updating Your Governing Documents. Kirsten Hentz will be presenting. That's a Zoom session. On April 23rd is the CAMU Luncheon at Seasons 52 in Palm Beach Gardens at 11:30 a.m. The topic of presentation, construction contracts and funding construction projects, will be presented by Ben Hedloff from our Palm Beach Gardens office. April 24th is another CAMU luncheon, this time at the Rodizio Grill in Dania Beach, 11:30 a.m. Covenant enforceability for condos and HOAs. Michael Bender will be present and presenting on that date. And the last item for April 25th, 11 to 3 p.m., we have a condo board member certification webinar with Kirsten Hentz from Tampa and Alan Schwartzide from Orlando, co-hosted by Artemis Lifestyles.
Busy month.
Busy month. Go to our website, kbrlegal.com, and click on the calendar, choose the event you want to register and secure your spot.
Tell people how they can reach your office before we go to our break.
You can call at 800-974-0680, or you can write to info@kbrlegal.com, or you can go to our website, kbrlegal.com. On the first page, there's a contact box. You can fill that out, and somebody will get back to you.
We're going to go to our break. When we come back, we have more with attorney Robert K. Bender Rimbaum. We'll be right back.
Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the Ask the Expert show. This is the first Thursday of the month. That means K. Bender Rembaum Community Association law firm located in Pompano, Palm Beach, also in Tampa, and offices in Orlando. We have with us, this is the first Thursday of the month, we do our South Florida show with senior partner attorney Robert Kay. And we will be going over the schedule again in the second half of the show. For those of you who missed us, we're going to go right to your questions. Connie in Boca Raton, we did our reserve study. I thought we were fully funded. What does fully funded reserves mean? We get a lot of those, Robert.
No, that's a good question, and there's a lot of confusion on this topic out there.
Yes.
So in order to determine what fully funded means, there's a formula that you have to apply. It's not a complex formula. It's a little bit of algebra, but and basically there are several components that you put together to determine what you need on an annual basis. And those components are basically each asset that is required to have reserves. You will determine what the useful life is of that asset. You will have a determination of how much it's going to cost to replace it. And you take the cost divided by the useful life to figure out how much you need each year to fund for that particular asset. So, for example, if you have a roof that has a 10-year life that's going to cost $150,000 to replace, you divide that $150,000 by the 10-year life, you get $15,000 per year. Fully funded on the roof for that year is $15,000. Fully funded does not mean that you have to assess for $150,000 now, because that's how much it's going to cost to replace it. Fully funded means for that current fiscal year, how much do you have to raise to keep on track so that at the end of the useful life, you'll have all the money you need to do the work. Now, it's not an exact science, because you take the replacement cost today, 2 years, the replacement cost is likely going to be different. And then 2 years after that, it'll be different again. So it's important to reevaluate the useful lives and the costs on a periodic basis during the time frame that you are reserving for it. You know, what's 10-year useful life today, something could happen to reduce that useful life to 8 years or whatever it would work out to be at that future date. So it's important that the board also undertake a periodic reserve study just to reevaluate and make sure your numbers are up to date.
Julia in Boca Raton, a lot of people from Boca Raton writing us. She wants to know, does a proxy have to be shared with unit owners? She also wants to know, are Zoom meetings accessible to unit owners for HOA? And can board meetings all be done by Zoom? Does it have to be a physical location?
Well, there's a lot of questions
That's a
there.
lot of questions right there.
Well, let's start with the proxies. The proxies are part of the election materials, and they are part of the official records of the association. And so any owner that wanted to inspect those records, those would have to be made available, and generally you'll have to keep those for 1 year. The second question was,
Zoom meetings accessible to unit owners for HOA.
yes, Zoom meetings are an acceptable way to conduct business. The Zoom meeting has to be open to the attendance and participation of the owners. And it's a good idea to have a physical site where owners who aren't real technically savvy or otherwise want to physically be there are able to attend and participate at that location. There hasn't been any judicial or arbitration finding that says that's a mandate. The statute doesn't say it. It's generally recommended that that be done. And the last part of the question was, once again?
Well, there's one to know, can board meetings all be by Zoom?
Yes. The board meetings can be done by Zoom. So we covered all the questions.
Okay. Jerry in Delray Beach, can we ask for too much as a board in regards to support animals? We're noticing people with 2 pets. Can we have a say in that?
Okay, well, with respect to the question, support animals under the law are not pets, so we wouldn't consider them to be pets. And this issue generally comes up in either a place that has no pets in their covenants, or maybe a size limitation in what a pet can be. And those will not apply to support animals under fair housing laws. There is limitations on what the board can ask, and yes, you can't ask too much, and that can create a problem. It's important when the board gets a request for a reasonable accommodation on a support animal that the board consult with its attorney to make sure that it has the proper format of presenting questions, it's asking the right questions, and not intruding into areas that could get it into trouble and raise the possibility of a claim of discrimination.
We've been doing the show for a long time. It seems like, God, years ago, we got so many questions about support animals, and now we rarely do. Is that just because everybody's educated now?
I think so. I think it was a hot topic for a while, and that things also tightened up. It was highly abused. Florida adopted legislation that makes it criminal conduct to fraudulently be obtaining these types of statuses. It punishes providers that are providing documentation without the proper medical background. And the federal courts have been issuing rulings that sees through the fictions that owners used to get away with. So, it's a pendulum that swings both ways over the years. As of now, I think things have settled in where everybody seems to know what their limitations are.
You used to do classes on support animals.
Yeah, it was a big topic for a long time.
Yes. Jerry
and we still do it once in a while.
Yes. Jerry in Delray Beach, can we ask for Kathy in Fort Lauderdale. She wants to know about closed board meetings. Are they required to tell us who attended the meeting? Do they have to report what was said in those meetings?
Well, a closed board meeting is a limited situation when the board is meeting with its attorney to talk about pending litigation or actual litigation or dealing with certain personnel issues. However, the statute allows for closed meetings, it's still a meeting. So by virtue of that, there needs to be minutes. And the minutes of a closed board meeting would simply be an indication of who's present. to show that a quorum was there. If there is formal action taken, unless it's required to be privileged, that would generally be in there, but there's no requirement. In fact, there shouldn't be anything of discussions or any of the sensitive topics can't be included in the minutes themselves. That would defeat the purpose of closing the meeting.
Somebody just texted us. We're going to be calling your office Monday. I'm interested in finding out if you make presentations to board members, and how long is your presentation? Yeah, that's a new question.
Call the office on Monday, and yes, we'll make presentations to board members. And depending on the topic, will depend on how long it takes.
Sounds like it could be a new client. I guess they want to know what all's involved.
We've done board member verifications as well.
Yeah, let's give them the phone number right now, since they just
800-974-0680.
And what are your hours at the office, Robert?
Oh, we start answering the phone at 9 o'clock until 5:30.
Okay. Let's go to, thank you for that question. Carla in Palm Beach Gardens. She's an HOA. I missed it when you were talking about what the authority of the Architecture Review Commission does. Can you go over that again?
Well, Architectural Review Committee is generally whatever the documents entitle or authorize it to do, or what is delegated to it by the board if the documents do not provide much specificity. Typically, in an HOA, there'll be a section on architectural review, and it'll spell out the ability to have a committee that handles applications for architectural modifications and specifications and functions of, and typically it's to review the applications and either decide whether to approve or disapprove, or make a recommendation to the board for the board to approve or disapprove. Ultimately, the board would have final say on the topic. Sometimes there is delegation to the committee to allow it to make the decision. So it really will depend on the documents as to how that all works out.
Sally in Miami, thank you so much for sharing so much legal information with us each month. We really appreciate your show. Can you have too many claims where we could actually lose our association's insurance?
Well, there is such a thing as having too many claims, which result in carriers canceling your insurance or creating a more difficulty in getting insurance in the future. Since insurance is generally an annual contract, you're up for renewal each year, and carriers will have their criteria as to what they're going to find acceptable or not. And it varies by carrier. So some may have a very low tolerance for claims and cancel after one or two. Others may allow you to have 5 or 6 or 10 and there's no issue. So it's going to really depend on carrier to carrier. There is no law on the subject, and they're allowed to make their own specifications, and as long as they're not unreasonable.
I know there's a lot of 55 and older communities out there. Randy and Boca Raton, many of our owners are aging out. Can the adult child serve on the board? These are condos that are handed down to the children. Do the children have any rights in the association?
Well, who qualifies to serve on the board is generally specified in the Articles of Incorporation. And if they're silent, then it can be anybody. And so it'll either provide in the articles that to qualify for the board, you have to be an owner or a member, or it may not. We've seen different variations. It could be the spouse or of an owner who's not on the deed, or it could be a number of different things. So the children's rights in the unit are not what we call vested or complete until the passing of the parent and there's a transfer of ownership. It's called a contingent interest. It depends upon something else happening. So your documents will really rule as to whether or not the children can serve on the board. But quite often the articles do not require ownership. So you do want to check that first. And in those instances, anyone can serve and the children would be qualified.
Let's we've still got about 10 minutes left. Let's go. Can we redo your schedule again for April?
Okay, April. Starting on April the 8th at 11 a.m. to 3 p.m. We have a condo board certification webinar. Kirsten Henson from our Tampa office, Danielle Brennan from Palm Beach Gardens will present. It's co-hosted by GRS Management. On April the 10th from noon to 3 p.m., HOA board member certification webinar. Emily Gannon from Pompano Beach will be presenting, co-hosted by Affinity Management Services. April 16th is the Tampa Expo. It's a live event at the Tampa Convention Center. Besides having a booth and meeting everybody who stops by, we'll also be presenting 2 classes, 9:30 Covenant Enforcement for Condos and HOA, 2:30 p.m., the 2025 legal update for changes that were adopted in 2024. And Kirsten Hentz of our Tampa office will present both of those. April 17th is the ACE Boca Breakfast at the Farmer's Table at 7:30 a.m. Breakfast. Topic, Covenant Enforcement for Condos and HOAs. Emily Gannon from Pompano office will be in attendance. On April the 22nd, there's another expo, this time Palm Beach at the Palm Beach Convention Center. We'll have a booth there, and we'll also present at 9:30 Covenant Enforcement for Condos and HOAs with Danielle Brennan presenting, and 2:30 2025 legal update with Jeff Rembaum presenting. Also on April 22nd, if you're not going to the Palm Beach Expo, you can tune in at noon to 1 p.m. The importance of updating your governing documents, a webinar, which will be presented by Kirsten Hentz from the Tampa office. April 23rd is another CAMU luncheon at Seasons 52 in Palm Beach Gardens at 11:30 a.m. Topic will be construction contracts and funding construction projects. Ben Haidloff from our Palm Beach Gardens office will be there and presenting. And then on April 24th, a CAMU luncheon at Rodizio Grill in Dania Beach at 11:30 a.m. This time will be covenant enforceability for condominiums and HOAs. Michael Bender will be present and presenting. And lastly, April 25th, from 11 a.m. to 3 p.m., we have condo board certification webinar presented by Kirsten Hentz from Tampa and Alan Schwartzide from Orlando, co-hosted by Artemis Lifestyles.
Busy month. I want to get this.
Attend, go to kbrlegal.com, click on the calendar for the webinars, on to register so you can get the login information for the live events. I don't know that you need to reserve yourself to any of those. It's good to know for the presentations at the expo how many are likely to come, so we have enough of the handout information. So if you want to register, that would be helpful.
We get I don't know why they send them to us, but people thanking you, they love your certification classes.
Well, we're happy to present.
Okay, this gentleman has been writing for the last several months, and we always run out of time, so I'm glad we have time. He's a condo. He said if no one runs, we've been talking about this today, if no one runs for the board, do you have to have an election? We are 121 units, and are lucky if 20 people show up.
So we're talking a condo, right?
Yes.
So the condominium election process requires that there be at least a candidate in order to have an election. If you don't have any candidate, that means the current board is unwilling to continue to serve. And you'll have no board unless the meeting is canceled for lack of anybody willing to run. And that would be the method of resolving. Otherwise, you'll have no board. But if the current board is willing to serve, which would be the result of canceling the annual election, and then they should put their names in to run timely by the 35th day. The election minimum participation requirement is 20%. So you were close to that in the number of people that were physically there. So you should be able to reach 20% in a mail-in vote. If you don't get that 20%, that's an issue that you should get with your attorneys to figure out the proper method. You can try again, or cancel the meeting and the current board would stay on if they're willing. If the current board does not want to run and there are other candidates that you couldn't get an election because you didn't get enough participation, board members can resign one by one and appoint the people who were running to take their place. That's a way around the election if you can't get enough people to vote. But the issue here is whether you get enough candidates willing to run.
Another gentleman from Deerfield. What does it mean to ratify a decision of a board outside the meeting?
Well, this is something that happens quite regularly in the world of community associations. Board members have periodic meetings, but things come up, and the time frame in between meetings, that the board doesn't have the opportunity to call another meeting and to make decisions. But decisions have to be made in the interim. And so technically the decision made outside of a board meeting would not be an appropriate decision unless it was done and by a written resolution signed by 100% of the board members. So if it's not a unanimous decision, but it had to be made, at the next opportunity on the agenda would be a ratification vote, at which point a majority of the board members present at the meeting could vote to ratify or basically adopt the decision that had been made outside of the meeting, and that resolves the legal issue of doing it outside the meeting.
We have a Justin in Boca Raton said he lives in a large HOA. I love your show. My staff also watches your show. Can people running for the board send out bios? And are they allowed to give us email addresses?
Give whose email addresses?
They want to know if they can get, I guess, residents' email addresses. So
They'll
they
get the
can
email
send out their
addresses
bio.
from the association.
Yes.
Okay. The answer to sending out bios is yes. Of course, you can send anything that you want that isn't legally compromised, and your bio is certainly not a legally compromised document. The email addresses of the unit owners are only available if they had provided approval to the association to receive official notices from the association at their email address. Otherwise, just their regular mailing address would be what would be available to a requesting owner.
Stacy in Delray Beach is in an HOA. She wants to know, she said, I'm delinquent. Can I still run for the board?
Well, in an HOA, typically, the last moment of qualification to run is going to be at the meeting itself. If nominations are taken from the floor. But you can't be delinquent in order to run. So whenever that time period expires in your HOA, if there's advance notice and absentee balloting like in condominiums, or if it's nominations from the floor at the meeting, if there's a delinquency on the account, then that individual would not qualify to run for the board.
This is from Tampa, listening to the show. Mel in Tampa, we're an HOA. We only have 2 board members and we can't get a 3rd member. How do we get anything done to our property? We have tried so hard to get a parking in the parking lot for a 3rd board member. We can't trim trees or pressure wash. It's really hurting us.
Well, from the question, it sounds like there's a 3-member board. So if they have 2, that's a quorum of 3. They don't need a 3rd to function. They just need the 2 of them to participate. So you're able to function with 2 so long as your board size is 3. If your board size is 5 and you need 3 to get to that number, then you have a problem. And you're unable to take formal action without getting that 3rd board member to meet the quorum minimum. So it really depends on what your problem is there. And if it's the second, where you have 5 seats available and only 2 people willing to serve, you might look at the documents to see if there's a method for reducing the size of the board to 3, whether it's an owner vote or a board decision. And if you can accomplish that, there are methods you could try to accomplish that to reduce the size to 3, then the 2 of you can function. Otherwise, the only other remedy would be for someone to petition the court for a receiver to be appointed to operate the community as the board until such time as a quorum of the board can be seated. And that can be very expensive to the community because the receiver, it charges an hourly rate. It could be $400, $500 an hour. The receiver can hire his own attorney and pay that individual whatever their hourly rate, as well as the association's attorney. And all of these expenses will come out of the common funds of the community, and that can significantly increase the assessments that the owners are going to have to pay, which could be an incentive to get somebody else willing to be on the board. So those are the basic options for you.
Well, we've come to the end of another show. We still had about 8 or 9 more questions, which we will save for next month. Robert, tell people again how they can reach your office.
We're available at kbrlegal.com. On the website, you can fill in the contact information on the first page. You can write to us at info@kbrlegal.com, or you can call 800-974-0680. That will work for all 4 of our offices: Pompano, Palm Beach Gardens, Tampa, and the Orlando area.
As always, we love having you on. We'll see you again next month.
All right. Happy April, everybody.
Kay Bender Rimbaum, Community Association Law Firm. That's it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.